Hi, this is Keith Pabian from Pabian Law. Today, let's discuss in-country recruiting. And what I mean by that is the process of recruiting H-2B visa workers that are currently working at opposite season employers. So as an example, let's say that you are an employer in the northern United States that has a summer season. This is the idea where you're recruiting workers that are working in the winter season, whether that's South Florida, South Arizona, Hawaii, or at or near a ski mountain. All right, so when you're recruiting in-country workers, there's a few things that you need to be very mindful of and careful about. First of all, workers can only stay for 3 years consecutively before they have to go home for 60 days. It used to be 3 months, now it's down to 60 days. Just remember, the workers need to be home for the full 60 days, so they actually need to be planning to travel on the other days, right? So that on the first and the 62nd day, and have those 60 full days at home. As long as they do that, they can stay for 3 full years, which basically means 6 seasons. The employer still needs to go through the whole H-2B process, but those workers can bounce back and forth between seasons. So when you're recruiting the workers, you need to make sure that they have enough time left in that 3-year period to work your entire season. Now, one other thing that you need to be careful about is there a gap between the end of their season, where they're working for the opposite season, and the beginning of yours? So let's go back to my hypothetical where you're a summer season employer. Let's say that you have a May 1st start date, and the worker, their season for the winter property ends on April 15th. With that 2-week gap between April 15th and May 1st, that gap can be very problematic to the point of the government could force you to pull that worker off of your petition or have the entire petition denied. One of the pieces of good news is that the worker can potentially have a grace period. Grace periods used to be for 10 days. Now they can actually be granted for 30 days. But the key here is that the grace periods are not automatic, and that they actually have to be granted and approved by either U.S. Citizenship and Immigration Services, if the worker transferred to their current property, now they're trying to come to you, or issued at the border when they came into the United States by U.S. Customs and Border Protection. Either way, we at Pabian Law, we're always happy to help our clients navigate the issue of understanding if there is a grace period and potentially applying for it later. All right, so first issue was the 3-year limit and whether they have enough time left to work for you. Second issue is there a gap between the end of their season that they're finishing and the start of yours, and whether there's a grace period available. And the final issue I just want to make sure that you're aware of is overlaps. So let's say that you have that May 1st start date, but the winter season property goes through May 15th. In that situation, there's this overlap where theoretically the worker can't be in 2 places at once. And what we see with overlaps is, yes, we can get them approved, but what always ends up happening is that you end up disappointed. And a lot of people end up being disappointed, right? The winter employer risks having the worker leave early, the summer employer sees them coming late, and the worker is feeling very torn between 2 employers. So the more that you can avoid overlaps, the more happy everyone will be. All right, so always let us know if you have questions. We always provide our clients at Pabian Law a very substantive instructional sheet on how to navigate these issues, but we are always here to help our clients navigate these. And I will tell you, they're always a little bit more complicated than they seem on the surface. As always, we're here for any questions that you have, and thank you all so much. Take care, everyone.